our hope in these conversations is to really get your individual thoughts, concerns, maybe even recommendations as to what South Dakota can do to ensure that, that their bar is a fair and equitable process. And not only that, but, that they're doing what they can in order to increase access to justice in rural areas of South Dakota.
Okay, I'm trying to turn my volume up, and I haven't quite figured out how to do that.
Oh
So,
no.
but I do hear you. It's just not as loud as I'd want to hear you. But let me see.
Yeah, would it be helpful if maybe I put some questions in the chat, and that way, if you can't hear me, you can.
I actually no, I can hear you good enough. I can hear you. We'll just
Okay,
okay.
sure. So, would you mind introducing yourself, sir?
My name is Roger Barron, and a little bit of background. I'm a retired law professor. I taught law school for 30 years. 5 years, the first 5 years was in Houston at South Texas College of Law. Then I taught for 25 years at the law school in Vermillion from 1990 to 2015. And I retired in 2015 from teaching. So my designation is Professor Emeritus. And so I taught, I think it's important to note that in teaching at USD, I taught the required course of civil procedure, which is mandatory for all first year students. It's 3 hours in the fall, 3 hours in the spring. And so every law student that came through the school in those 25 years were required to take my civil procedure course. Then I taught 2 upper level courses, insurance and family law, and those were electives. Those weren't required courses.
Awesome. What are you doing now that you're retired? Anything fun?
Well, I'm still affiliated with the law school, and I monitor court decisions, and I provide summaries. Today, I summarized 2 brand new South Dakota Supreme Court decisions and one decisions and one Eighth Circuit opinion from South Dakota. So, and I also run the listserv, USD Law, which is a listserv for lawyers and judges and law students and people in the legal community. It has about 800 subscribers, so I do that. And none of that work is full time, but that's
Sure.
I do that.
That sounds like a lot of fun. And hey, at least you're keeping your mind active and you're part of the community still. And that's awesome. So we do have kind of a set of questions, and I'd like this to be more of an organic conversation. So I don't know if it's best for you just to provide your overall opinions and viewpoints about the current bar process in South Dakota, or if you'd rather just kind of go down these next, and they're so broad, but also just so you know that this is going to be an entirely confidential conversation. We're not going to affiliate your name or identity in any way, shape, or form with the answers that you provide. So rest assured, don't worry about it. I'm not going to say Mr. Barron said this. So all of your answers are confidential.
Well, first of all, I don't mind that it be revealed, and you have my permission to do that. I think the more people that hear what I have to say, the better, and that it's identified with me. I've kind of looked at some of the organic questions that was on the survey. I don't know that I need to go over those, but I definitely have some thoughts that I want to share with you, and we can either
Sure.
I can either share those thoughts now or later.
Oh no, go for it. I'm gonna go ahead and mute myself because I'm kind of a loud typer. I don't know if you can hear me.
Okay,
So
no,
go ahead, sir.
yeah. Well, I think what we're talking about in terms of education, the principles of education is assessment. How do we assess that these students or the applicants have learned what we think they should learn to proceed to the next stage? Now, my undergraduate degree is in education, and so I learned about assessment before I went to law school. I taught college algebra, and I taught junior high math, and I've taught law school for 30 years. And I'm very acquainted with the concept of assessment. I've lived my whole life dealing with the prospect of how do we assess the students' work in the classroom. And, in terms of, let's set aside the skills part, because I haven't really been involved in assessing skills like oral argument or trial practice. So that's a different category. But in terms of learning the substantive knowledge of the law, and I want to speak particularly with respect to civil procedure, because it is a mandatory first-year course. It's kind of a boot camp. Typically, there's a significant attrition rate, 10% flunk, or probably 15 to 20% get D's or F's. And so that's kind of a good parallel to the bar examination. And in testing the students, I have traditionally used three types of questions. I've used essay questions, short answer questions, and multiple choice questions. So I've used them all. And I test in civil procedure, a student who took my course would have been tested 3 times, because as a first year entering student, I give them what's called a trial exam or a practice exam. And then I gave them a final exam at the end of the fall semester, and then I gave them a final exam at the end of the spring semester. And all of these exams I put together. And I have found that in a typical scenario, and I would look closely, I would always go back and review how the students did based on the questions, and so on. So I would get a result on the multiple choice section, I'd get a result on the short answer question, result on the essay question. And I would find typically that probably the majority of the students perform at the same level on my multiple choice questions as on my essay questions, generally speaking. But I also found that there were students who did very well on the multiple choice and then did poorly on the essay questions. And I found that there are students who did well on the essay questions and didn't on the multiple choice. So that would tell me that, and now we're in the mode of trying to help these students as they're coming into law school to learn how to go to law school. So I would consult with these students individually, and if I got one that did well on the essay but on multiple choice, and okay, now we need to work on the multiple choice, and here's some things that you can do to think about how you work on the multiple choice. And people who did well on the multiple choice but on the essay, we do the same thing. And so invariably, what I'm saying, I found that there are students who know the material but don't do well because of the testing technique. And so my goal has been to not have a student do poorly on an exam because that student doesn't know the testing technique. And so I would make adjustments. And so now I use multiple choice questions heavily. I probably use that more than anything else. Over my 30 years, I'm trying to figure it out. I have, and this is a conservative number, I have written, edited, revised, and used at least 5,000 multiple choice questions for my classes. And so I found that multiple choice questions, in terms of the person who is drafting the questions, they have some drawbacks. And let me also back up just 1 second. In terms of educational principles of assessment, I think generally speaking, for our purposes, we can talk about 3 levels of assessment. One is recognition. That's the most basic level. One is recall. You can ask a student a question. Can the student recall the material? Recognition, you give them 3 sets of time limits, and you say which time limit applies for this statute of limitations. Recalls, you ask them, what is the statute of limitations for a tort action? And then the more sophisticated, and certainly the more important, is application or analysis. Trying to get a student to take what they've learned in the class and apply that to a set of facts. Now, essay questions are great for testing application and analysis. They're not so good for simply testing recognition and recall, because if they don't see the issue, they're not going to come up with that. So that's why I believe and short answer can be good for both, and I use that. So what I found, and I've drafted, I really think it's more than 6,000 multiple choice questions. What I found is I learned this the hard way because I made mistakes. Is I found myself drafting questions that were very, very difficult because I wanted to build in an application or analysis process. And so I write this really long question and then come up with and then I gave out the questions to this class, and a lot of them were missing that, probably over a majority. And so I even at one point I even tested with questions that had 8 possible answers, because you could do whatever you wanted. And so I had A, B, C, D, E, F, and G, and the bottoms were called. So over the years, I've really learned that multiple choice questions, there is a tendency by one who's drafting one to put too much into it to test the concept that you want to test. And so a student who's taken my class will tell you that I do have some difficult multiple choice questions, but not all of them are. And I have easy ones. I cover the spectrum from the easy to the more difficult, and I include them all. And I will make an assessment each time I teach a class. That'll be a bank of questions, whether or not I'm going to use them again. So, I've also found that in terms of time constraints, there's a wide diversity of issues that students deal with. I have had some really bright students who've taken a test that I've designed for 3 or 4 hours, and they're done in an hour and 20 minutes, and they walk out and they get a high grade. And in that same class, I'll have students who, when it's getting close to the end, they still haven't read all the questions because they're slow readers, or they have a disability, or because there's a language barrier of some sort. English is a second language. And so I have been very tuned in my testing and made adjustments for, I've never wanted my students to fail because of the design of the test that I utilize. Now, that to me is really important. And I have other things I want to share, but I would just simply say this. My number one concern today is the utilization of 200 multiple choice questions in a time-constricted setting, which probably more students than not either don't finish on time or come close to not finishing on time, to use that as a valid measure of assessment. To me, I've seen these questions. My questions are not like the bar exam questions. I don't have a half a page long hypothetical, and then you have a multiple choice answer. So these questions are not fairly designed to provide the type of assessment that I wanted to provide in my classroom and did provide to students. A lot of these questions, there's absolutely no doubt that a student can know the material and do very poorly on these questions. And even if you take a course to learn how to take the questions, that's not going to solve the problem. So that's my number one concern is the reliance of these time constraints for 200 multiple choice questions.
Thank you for that, sir. I don't know if you're very familiar with the Next Gen Bar exam that's supposed to come out in 2026. It's going to involve some short answer questions, kind of like your recall, and as well as like a couple more essay questions, so application and analysis. And there's going to still be obviously a multiple choice component to the bar exam, but do you think with the addition of the Next Gen Bar exam, do you think that South Dakota should, move to the Next Gen Bar exam and implement it when it becomes available, whether as a UVE or not? Or do you think that still isn't going to help, some of the students that you've seen in your class?
Well, that's a great question. And my answer is, I have no problem going to the Next Gen Bar exam, provided that's not the exclusive pathway to licensure. Because the current system is flawed. It's absolutely flawed. And, I'm not happy with multiple choice questions with time constraints. If you tell me there's no time constraints on that, I'll be better. But if and one of the important aspects of the Next Gen Bar is you would retain some portability. I would imagine. And so that's a concept I don't want to lose, but I think that we can be broad-minded enough to have alternative pathways for students other than just the bar exam. What we have now is a catastrophe. It really is.
Yeah. And speaking of alternative pathways, do you have any pathways that you prefer or that you think would be that can work within South Dakota, knowing that, there's like little pockets. I know that a lot of the law school graduates prefer to go to these larger firms and in the bigger cities. Um, but what kind of alternative pathways can you see either helping students actually pass the bar or become licensed, or to actually provide services in some of the rural communities that are severely lacking in any kind of judicial resources?
That's a good question. I will say that yesterday or the day before, the Minnesota Commission released its report. I like its report. I would fully endorse that report and that sort of result here. But let me say this in terms of the alternative pathways. I'm uncomfortable with the phrase the diploma privilege. And even though we had legislation in support of that, I think that phrase, and we did that for 60, 70 years and it worked fine. Many of our judges and lawyers, and I'm not opposed to the diploma privilege, but that's not necessarily what I'm advocating. What I advocate is at least two different pathways. And one is what's called the curriculum-based licensure. And that's basically what Wisconsin does. Wisconsin is not a diploma privilege jurisdiction. Wisconsin is a jurisdiction when you go to law school there, if you take the prescribed courses prescribed by the Wisconsin Supreme Court and successfully pass those courses, then you become licensed. You can become licensed without having to take the bar exam. So that's curriculum-based licensure. I'm a huge fan of curriculum-based licensure. Now we don't, in South Dakota, we would have to tweak things to do that. There would have to be coordination, and there's not been any effort to do that. But I am in favor of curriculum-based licensure, not just blanket, somebody goes to law school and gets a diploma, then necessarily they become licensed. And then I am a fan of apprenticeships. I think, I speak, I know for a fact that our public defenders' offices have trouble retaining students. They have students that want to be public defenders, and some state's attorney's offices, both public defender and state's attorney's offices here in Pennington County, will get new graduates who are permitted to practice until they take the bar exam, and then they fail the bar exam. But they're very skillful at what they do, and they could be very good lawyers in terms of being a public defender or an assistant state's attorney. And so there are these areas naturally provide an opportunity for an apprenticeship where you get these new graduates and put them on a track so that they can become licensed that way. One of the things that in law school that I've made many comments in law school from over my years teaching is you're going to, as a student, if you're coming to law school and I talk to you your first week you're there, I said, there's lots of criminal law lawyers out there, and criminal law probably is over 50% of what goes on in the practice of law. But you're only going to take 2 required courses in criminal law, criminal procedure. You may take an upper level elective, but you're not going to get more than 9 or 10 hours of law school education in substantive law and criminal law. Now, if you're going to have a student who's going to go out and practice criminal law, why don't we allow them to do that, provided, of course, they graduate from law school, they take the prescribed courses everywhere. Why do we prevent these people from effectively serving society in that capacity? So there is that notion to me, and there's so much civil law taught, and I didn't teach criminal law, but I would tell students, you go down to any courthouse, any state courthouse, and if you take all the files there, either now electronic, but if you take all the files there, over 50%, probably 60 to 70% of those files are criminal files. The remainder are your civil cases, your divorces, your tort actions, your collections, and that's not really representative. And so I think there's a huge disservice to the public of South Dakota in that so many of our graduates have been denied the opportunity to work as a public defender or assistant state's attorney through the current exam process.
Thank you for that. One of the ringing feedback that we've had regarding, I know it's called diploma privilege, but it's also curriculum-based licensure, is that, the law school doesn't want to look bad. A lot of people who oppose any kind of diploma privilege type pathway, they don't feel that professors would purposely or will fail students who shouldn't continue. How do you feel about that? Do you have faith in the
Can you repeat that last part? I kind of had. Yeah, don't. Can you repeat that last part? I kind of had. Yeah, you don't feel the professors do what can or.
That they won't fail students because they want to keep their graduate numbers high.
Well, that wasn't an issue when I was teaching. Things have evolved, and what we generally did in terms of trying to weed out the students that we thought shouldn't go on is that usually happened at the end of the first year, and so that's why you want to have, and I called it a boot camp type of thing. That's why our first year courses were rigorous and the grading was rigorous, and we had guidelines as to grading that would occur. And that's where we weeded out most of the students who I'm speaking institutionally, which the law school believed probably wouldn't make it as a lawyer. Now, that wasn't perfect. And some of them would get through and they'd be put on probation. When we put them on probation, for a student who was on academic probation, they had a prescribed curriculum. They couldn't take the classes where grades were easy. They had to take the hard classes, the code courses, tax, commercial law, constitutional law is mandated. So as an institution, we were tough up front. We had a 10 to 15% attrition rate at the end of the first year. We continued to have a stringent requirement for those who were readmitted on academic probation. Now, the problem with the upper level, you get the elective classes on the upper level. I think if it's a required course, you still need to have the stringent grading requirements. I think con law is a mandatory course. And I don't think con law should be a fluff course where the lowest grades given is a B-. That shouldn't happen. But if the students in the upper level classes take like insurance or administrative law or conflicts of law, a lot of times you'll find out that only the top upper echelon is taking these higher courses. And so mandatory grading scales in the upper level, a little bit more difficult to do, and it's probably not something that you want to do, but that can be handled by the law school. Now, I don't know what they're doing now. I retired in 2015, but we did that, and see that's why I favor curriculum-based licensure, because right now you can go get a diploma at our law school or any other law school without taking some difficult courses like estate planning, like income tax, like commercial law and commercial 1 and 2, and a student can graduate. And so, yes, I would agree that there's an opportunity for students, undesirable, I hate to use that term, but undesirable bar applicants to slip through in a naked diploma privilege jurisdiction, even though that's what we did for many years. So I understand that concern completely, and I'm sympathetic to it, and I agree with it.
Thank you. I want to be mindful of our time. We have about 5 minutes left. So aside from the bar exam, do you feel there are other issues that deter people from becoming a lawyer in South Dakota?
Well, that's a good question, and I really, I don't really have an answer for you there. I haven't really thought about that ahead of time. Because the question's more related to how you recruit students to go to law school. South Dakota continues to have a problem recruiting top students because they can go to law school elsewhere for a scholarship. I think it's probably a mistake to go out and advertise to the world your life would be great if you become a lawyer. That's not how it works. So I don't really have an answer there. I mean, it's an age-old problem.
Definitely. And this is such a silly question, but we ask everyone, if you had a magic wand, what changes would you implement?
What system would I implement?
Change.
Okay. Hang with the next gen bar. Don't let go of that, but develop a curriculum-based licensure and develop an apprenticeship program. I know for a fact that we have lost students who graduated from our law school and have been intimidated by the South Dakota bar out of even taking it for the first time, or have failed the bar and have gone elsewhere to become licensed. Now, why do I know that? Because people know that I'm sympathetic to these students, and they come to me with I know I've been out of time. Let me tell you this. The class of 2016, 39% of them passed. These are good students. I know this class intimately. They dedicated their law review that year to me. I was selected to be the class speaker at their hooding ceremony in their May graduation. I was the only faculty member ever to be invited to be the hooding speaker in the May ceremony. These students, this class of students, is no worse than any prior class of students. And in all the previous years, we've had 10 to 15% failure. And I could look at that, and the faculty did. We'd get together and we'd look at the students who'd failed the bar, and yeah, okay, that guy, that's probably they probably did a good job keeping him out. That's probably accurate. But when you come to me and you tell me 61% of these students failed after they devoted time, money, sweat, the emotional turmoil going through a bar exam, and you're kicking them out, that's wrong, flat out wrong. And that has a deterrent effect. Who wants to take the South Dakota bar if nobody can pass it? And that's the reputation we have out there right now. Not that nobody can pass it, but only a select few can pass it.
Just out of curiosity, we've had some people comment that because, there's like requirements of how many seats that law schools have to fill, that maybe USC admitted students into the law program that never should have come into the law program, whether it was like low LSAT scores, or maybe they just don't have the character and fitness for it. How would you respond to those kinds of accusations?
Well, I used to sit on the admissions committee, and character and fitness is different than academic ability. And we were really stringent in examining character and fitness. I mean, the application required them to disclose their criminal record, issues of debt and lawsuits and so on. And so, I don't know how the law school is functioning now, but the entire time I was there, we had a very, very hands-on, aggressive screening committee. And so we definitely had students who met the criteria for grade point and LSAT, but we said no to their admission because we required more information or took a look at it. So that's a separate issue. And of course, in terms of becoming licensed, that's a separate issue. The bar exam really doesn't relate to character and fitness because we have a rigorous process there.
Before I let you go, sir, do you have any final comments you'd like to provide?
I do. When I got to the law school in 1990, I worked closely with the members of the Bar Admissions Committee, and we worked together in helping them write questions that the students took for the exam. And they wanted to know what we were teaching. I told them what we were teaching, especially in family law, and they would test them over these things. And so the bar examiners, and in terms of assessment, this is important. The bar examiners were providing exams that provided an assessment over what they were supposed to be learning, in law school. That's been cast aside. The bar committee today outsources all the determinations to the NCBE, both essay and multiple choice, and there's no hands-on communication that I'm aware of, at least not when I was there. What are these students learning? What should we test them over? And so they signed on to this national outfit. Now, with the exception of family law, because that's a different thing with Professor Pommersheim's question. And so we've lost that element. And it was after we lost that element that we started seeing the great failure rates, as well as changing the rules, making it harder to pass, not allowing a scaled comparison,